Yes, please.
From the daily list, item number 1.
Please, Your Lordship. Lordship, Mr. Paul is not available today. I'm praying for
Louder, please.
Mr. Paul is not available today, Your Lordship, so I'm praying for some time, Your Lordship.
For admission.
Admission hearing, Your Lordship. Your Lordship, we have also taken steps upon the private respondents in this matter.
Service is complete.
Service, Your Lordship, we have taken dusty service and respondent 5 and 6, they have accepted. Respondent 4 has recused herself to accept the...
Mr. Deputy Solicitor General, you are representing all the respondents.
My lord, I am only representing district council, my lord.
I am for 2, Your Lordship.
State.
I am for STL.
Any other?
But the judicial officers whose appointments are under challenge, my lord, they are respondent number 4, 5 and 6, my lord.
Their appointment is challenged.
Your Lordship.
My lord, here what happened, well, the district council has a district council courts, my lord. So district council is appointed after issuing advertisement 3 numbers of judicial officers in 2021, my lord.
Their appointment is challenged.
Their appointment is challenged, my lord.
They are respondents.
They are respondents.
Where are they? They are necessary parties.
Your Lordship, we have already taken steps, Your Lordship, through postal service and through dusty. Your Lordship, in the meantime, you can also file an affidavit of service upon the private respondents.
If they have not been served, you take steps that they are served. We are keeping it 2 weeks since.
My lord.
2 weeks, Your Lordship.
List this appeal on 3rd December. Next, service is to be positively completed on all the respondents and a proper service report filed. Full stop. An affidavit of service is also to be filed in relation to dusty service.
Okay.
Highly obliged.
Item number 2.
Well, here we are taking steps for issuance of notice, my lord, and we have received the confirmation from the post office, my lord. We will file an affidavit to that effect, my lord.
1 week.
1 week.
This miscellaneous case is adjourned till 25th November
My lord.
to enable advocate on record for the appellant to file a service return report.
Deal.
Item number 3.
May it please your lordship. My lord, in this case, before my learned friend started, my lord, just now I have received, my lord, the instruction to appear for the sole respondent. In fact, I have just filed my affidavit. I'll just pray, my lord, at least. Ukalatnama, my lord. I filed my Ukalatnama. And just pray for some accommodation, lordship. If you
2 days? 2 days?
My lord, if it can be next week, my lord.
Lordship.
What is this miscellaneous case?
Your Lordship, this is application for condonation of delay. There is a delay of 59 days, Your Lordship, in filing the
Condoning
appeal.
that delay.
55 days, Lordship, I'm sorry.
Leave is granted to Mr. to appear for the respondent on the undertaking to file a wakalatnama in the course of this week.
Wakalatnama has been filed, Your Lordship. Just I have filed it.
Then it is all right. That is all right. We have perused the petition. Full stop. Sufficient cause is shown. The delay of 59 days in preparing this appeal is condoned. We allow this application for condonation of delay under Section 5 of the Limitation Act. Next, we direct the registry to register the appeal. Paragraph, list the appeal for admission. When? 1 weekends
Lordship.
on 25th.
Apply, Your Lordship.
Apply.
Item number 4.
May it please Your Lordship. Lordship, I have filed my rejoinder as all pleadings are complete, Your Lordship. Can you pose this matter for hearing?
What is this miscellaneous case for?
That is for
Different directions, Your Lordship. Proceed, Your Lordship.
This was order of the tribunal.
no, Your Lordship. This is a writ petition challenging
Challenging the service rules.
the amended rules, Your Lordship. There is a certain quota, Your Lordship, so far direct recruitment is concerned and the promotional pools are concerned, Your Lordship.
You are ready?
The arguing counsel, Mr. Philemon Nongbri,
Sorry?
the arguing counsel, Mr. Philemon Nongbri, due to his medical emergency, Your Lordship, within the family,
Who is appearing in the matter?
Mr. Philemon Nongbri, my senior colleague, Your Lordship. Can you have this on the next day, Your Lordship?
When?
Lordship, the pleading are complete. You can fix for hearing, Your Lordship.
After vacations.
Today is one day.
18th.
18. Lordship, if this matter come on 4th December, 4th or 5th December, Your Lordship.
This writ petition is ready for hearing? Both learned counsel pray for accommodation to get ready in the matter. List this, by consent of learned counsel for the parties, list this application on 4th December.
Apply, Your Lordship.
Item number 5.
May it please, Your Lordship. In this writ petition, my lord, Meghalaya Mineral Cess Act was under challenge, my lord,
Yes.
and we were awaiting the outcome of the pending matter, issue pending before 9 judges bench, my lord. Because the issue was whether the state has the legislative competence to tax the mineral or not, my lord. That issue was pending before the Honorable Supreme Court before 9 judges bench, my lord. 9 judges bench has held that the state has the competence to tax the minerals, my lord. So therefore, the issue is squarely covered by the judgment of the Honorable Supreme Court, my lord. And this is the only limited issue, my lord. If I can show the prayer.
Hey, please, Your Lordships. Lordships, today I'm seeking for some accommodation because the conducting counsel is out of station and he's unavailable. I'm praying if a short date may be fixed, Lordships. In the meantime, we'll also get to examine the judgment, Lordship.
This is a writ petition.
This is the writ petition, my lord. This is the writ petition challenging the vires of State Act imposing tax on minerals, my lord.
And the Supreme Court has said the state is competent.
State is competent, my lord. 9 judges bench, my lord. That judgment is there, my lord.
Please give that.
Copies are there. You already given. .342, my lord, at page 134. Paragraph 342 is the conclusion of it. .342B, my lord. May I place entry 50 of list 2 does not constitute an exception to the position of law laid down in MP v. Sundara Mayer. Legislative power to tax mineral rights vests with the state legislature, my lord. And E also, my lord, the state legislatures have legislative competence under Article 246, read with entry 49 of list 2, to tax land which comprise of mines and quarries, mineral bearing land, falls within the description of land under entry 49 list. This controversy, my lord, and if your lordship will kindly see your lordship's order.
But then why at the end, 343, the registry is directed to take administrative decisions from the Honorable Chief Justice
Yes, my lord.
for placing the matter before an appropriate bench?
The issue, my lord, was referred whether the competence is there, and separate petitions were pending before division benches of the Honorable Supreme Court. In the light of law clarified by the Honorable Supreme Court, my lord, now the matters will be decided by each the respective bench where these issues are pending, my lord. And if your lordship will see your lordship's order of 30th March 2021, your lordship may kindly see 30th March order. March 2021 order, my lord. The issue sought to be raised in the instant writ petition is relatable to an issue which is pending consideration before larger bench of the Honorable Supreme Court, since there is a conflict between a 5 judges bench and 7 judge bench of the Honorable Supreme Court. This will appear from the judgment of the Honorable Supreme Court in Mineral Area Development Authority versus Steel Authority of India, reported in 2011 4 SCC 450. In such circumstances of the instant case, we are of the view that instant matter is required to be adjourned sine die, with liberty to mention once the Honorable Supreme Court finally decides the issue which is in conflict. If the state takes steps against the writ petitioner during the pendency of writ petition, sine die for all such steps shall abide by the result of writ petition, my lord. So the matter was adjourned, this writ petition was adjourned, my lord, sine die awaiting the judgment and order of the Honorable Supreme Court in Mineral Area Development Authority. And that judgment, my lord, has been delivered by 9 judges bench, my lord. Holding the power of the state government, my lord.
My lords,
Nothing is left.
my lords, if we may be allowed to just examine the judgment, lordship, then a short date may be fixed for conducting counsel to be present as well, lordship.
He would have something to submit, or what? You are just ensuring he is earning fees here.
No, lordship.
What he will submit here?
Not submit, lordship, just for us to examine the matter at the judgment, lordship.
Why was it not examined? To 2024, this is delivered.
July 25, 2024, my lord.
Then
My lords may fix it on Friday, lordship. He'll be available on Friday, lordship.
you are aware of this judgment or not?
Lordships.
Then what is there to examine? From July, you are examining the judgment. Anyway, you are a junior counsel. We do not want any blame to be thrown on you that because of you the matter got disposed of. We are keeping it, but there is nothing left.
Lordships.
Please take down. We refer to the order of this bench dated 30th March 2021. When was the judgment passed?
24th July, my lord.
Paragraph.
2024.
Learned Advocate General brings to our notice a judgment and order pronounced by the Supreme Court, pronounced by a 9 judges bench of the Supreme Court on 24th July
Yes, my lord.
2024 in, give the cause title, blank versus blank,
25th July, my lord. Sorry, my lord. 25th July.
5th July. They will never put the date in a conspicuous place. They will just
Yes, please. It's
hide
very
it
difficult to
somewhere.
find, my lord. At page 6, that date is there, just above the appearances.
In all the courts, they will hide that date. It should be conspicuous, absolutely. In blank versus blank. Or reported in 2024, SCC online, SC 1796. This is the majority judgment. Which
This is the majority judgment. Justice Nagratna has given her dissenting judgment. She was the lone member, my lord.
yes. In paragraph 342, the court by majority has inter alia opined as follows. B
And E, my lord.
and E. What have we said?
In paragraph 350, comma, the court by majority has entered area opined as follows.
That's all. The writ petition questions the competence of the state legislature. To enact the Meghalaya Minerals Cess Act 1988. And seeks a declaration that it is ultra vires the Constitution of India. Paragraph. Learned Advocate General submits that this issue is decided by the above judgment of the Supreme Court, and nothing remains to be adjudged in this writ petition. However, learned counsel for the appellant prays for time on the ground of her senior to make some submissions on the issue. Paragraph. Accordingly, we direct this petition to appear for orders on 21st, Thursday.
Grateful Lordships.
Item number 6.
Sure, I've just given a small brief note as suggested by Your Lordship the other day. I prepared a small brief note, Your Lordship. My arguments were
Is it
completed.
arbitration matter?
Lordship, yes, my arguments were completed and Lordship has just requested.
Yes, yes. Yes, please.
Your Lordship, here just prepare some judgment. Okay. So Your Lordship, here I just Your Lordship, I'll be limited to the 2 points only. Herein, Your Lordship, this arbitrator has passed the award and didn't consider the counterclaim, and due to this, we pay for the application under 34 of the Arbitration Act. So here, in Lordship, last question is considered. Then under section 33, we should go to the arbitrator. But according to me, Your Lordship, I have given here my judgment also that it is not required to go for the arbitrator because he is the functional official after passing the arbitrator award, and we have rightly filed the application of 34 of the Arbitration Act. And secondly, Your Lordship, this the arbitrator, when he is appointed, he was appointed by the High Court. May I kindly refer to the page 110, Your Lordship, of this petition. What is the arbitrator, when this arbitrator appointed, whether he was given only the specific claim or arbitrated to be decided the full claim, including that. Here, if this arbitrator has limited by himself, then this is the threshold rejection of counterclaim, and that also after taking the counterclaim and the reply from the opposite party. So here you will see this page 110, paragraph 8. After proper application of mind, I am of the view that this retired Chief Justice Engineer may be appointed as sole arbitrator to resolve the disputes in the case mentioned above, and no prejudice shall be caused to either of the parties, as the parties have every right to plead their case before the sole arbiters as under of the Act 1996, and this is not readable. The amended provision of the paternity of appointment of the serving officer as sole arbiter highlighted by Mr. P. cannot be forwarded, and the decision to the apex court, and this as discussed above. Hence, to meet the end of justice, I do hereby appoint Major General Satya retired as sole arbitrator to resolve the dispute in connection with the work produced as SM Barrack, certain accommodation, SU quarter, JSU mess, and certain units of Telemoda near Agartala, Tripura, under contract number such and such. Joshi retired as also sole arbiter to resolve the difference and dispute in connection with the work, namely provision of including the annexure such and such. It may be another Ulysses. Then after that, the arbiter shall be entitled to require to be entitled such and such, and concern which shall be paid by the parties such and such, such and such. It's also made clear that arbitrator so appointed by this court shall resolve the dispute as early as possible. So here in this appointment, it is not given that only the whether claim has been submitted for the appointment of the arbitrator, this will be limited. There is no restriction that we cannot file the counterclaim.
Yes.
So you will see this. The view of the land arbitrator limiting to the page 134, paragraph 2. And whereas I, Major General retired citizen, was appointed sole arbitrator on the above matter by the Shillong bench of the High Court by its order on FU number 1/2018 assist to 1 by order 3rd April 2002 to adjudicate on the claimant list of 8 claims as included in the petition filed on 28 August 2001. So,
He has set claims and counterclaims.
so you will see here the arbitrator is saying that he is considering in the only the claim of the claimant.
Where?
From the, and whereas I Major General was appointed sole authority in the above matters by the Shillong bench of the Guwahati High Court by its order number FO number such and such to execute on the claimant list of 8 claims as included in the petition filed on 28/8/2000. So first of all, the arbitrator has taken the decision that only the 8 claim to be decided. But when he has called for this notice, at that point of time, he has given the opportunity to submit our counterclaim.
Yes.
So you will see subsequently, when this arbitrator passed the order, (138) you will see. Finally, when he was going to even concluded,
You see, you have to give everything a realistic meaning.
so
When the petition is presented before the court,
yes,
the respondent does not know the claim, so there is no question of any counterclaim coming at that point of time. So the petitioner will only enumerate his claims in the petition.
so
There is hardly any scope of claims and counterclaims being known before Section 11.
yes, Your Lordship.
So what the arbitrator has meant that the learned judge appointing the arbitrator has referred the claims mentioned in the petition to arbitration. So now after it is referred, the usual practice is that a statement of claim is like a plaint, is lodged. And when the plaint or statement of claim is lodged, then comes the question of a written statement or counter statement together with a counter claim, as in a suit. So what wrong he has done?
So Your Lordship,
Because he goes on to say, and whereas I entered upon the reference
yes,
and started the proceedings, inviting both
Both the
parties to submit their claims and counterclaims.
yes, Your Lordship. So he has taken the counterclaim from us.
Yes.
We have submitted. Subsequently finding in the page 138.
Yes.
In paragraph 3 to be there, you will say, in light of the foregoing,
Page
page 138,
38,
138,
113.
no, 138, 138, you will say,
1-3 thereafter?
8.
8.
Internal page 6, this paragraph will be 3, I believe you say, before claim number 1. In light of the foregoing, I, Major General Retired Secretary, do hereby make and publish this award, limiting myself
Yes.
limiting myself to the 8 claims as the petitions by the claimant to the engineer in charge and subsequently to the Honorable Court for the reason enumerated earlier as follows. So here clear, Your Lordship, though he has taken the counterclaim, did not consider the counterclaim. Now, Your Lordship, my brother colleague has referred section 33 that in the situation, the petition even before this court value was not sustainable, and the union should have approved under section 33 of the Arbitration Act 1996. Your Lordship, section 33 of the Arbitration and Constitution Act 1966 and scope of this review by the arbitrator is limited. Here, Your Lordship, when this arbitration award is part by the arbitrator, an arbit tribunal is bound by the principle of contest officio. And the arbitrator and with the arbit tribunal lacks its authority to revisit or modify the award or its decision. Your Lordship, even in the matter of this, in Grand Prasad Arjo versus Titan Industries 2023 1 SSC 153, and 63 in my compilation, Your Lordship, page number 63. Started.
What is the proposition?
Proposition is there, Your Lordship, this arbitrator has considered the petition for modification of the award, and then Supreme Court says no, it is not possible.
What is the
Para
citation?
Para 13.
Citation?
Citation, Your Lordship, 2023, Volume 1, SCC 153. I have entered the citation, Your Lordship, in my compilation.
Yes.
One. Another citation, Your Lordship, this 2024 SCC online, Allahabad 3920. I have enclosed this, Your Lordship. There are 7 and 8, Your Lordship, in this case. And
No, this is which paragraph? 2023 online, page 5 to 15.
this para 13, 1, 3. So you will see in, I'll refer to para 7, in 8, you will see just paragraph 8 I am referring now. That the principle of competence and competence which is empowered arbitrary tribunal to rule on their own jurisdiction, it is not creative fancy for unlimited authority, rather it is understood the tribunal's duty to determine its jurisdiction within the confines of the arbitration agreement and applicable law. The authority of arbitrary tribunal to correct, interpret, or supplement their award does not extend to revisiting the merit of the dispute or reconsidering the substance of issue that have already been decided. Arbitrary tribunals are bound by the principle of functus officio, which hold that once an award has been rendered, the tribunal jurisdiction over the dispute is terminated, and it lacks of authority to revisit or modify its decision in absence of specific statutory provision of the country. So here you will say arbitrator has not considered and threshold rejections of our counterclaim. If we defer the application before the arbitrator, it will be revisiting the whole thing, which he has not the authority. And option to us only to go for under 34 of the arbitration. Here it's a as regard to this counter claim. Yes, as regard to the adjustment coming. You will see, I would like to refer the 1994 Volume 4 SCC 665.
Yes.
The paragraph 5, 7, and 11, you will see. In this case, you will see it is gist of the case is there here. Arbiter did not consider the counterclaim, and it is considered the nil award. Therefore, this Supreme Court has set aside the award and remand back for the matter to limit the executive stress. This is finally is coming in. This the 5 was related to same matter.
You are referring to saw pipes. (1994) 4.
Yes, you will see. Is 665, and in I am referring this no para 11. You will see my compilation is page number 81.
Remanded.
You will see this paragraph 11. You will see. I just read. You will see. It is clear from the above text and legal position that the arbitrator committed misconduct in non-application of his mind in his deciding claim 11 and 12. It being non-speaking award, it is difficult to find whether he had applied his judicious mind in his deciding which he has to claim. The respondent would be entitled to, and in particular on the funding of the High Court in his behalf. Therefore, the award in respect to the claim 11 and 12 is set aside. The order of the High Court to award such and such set aside. Since the counterclaim was not considered, the matter required determination. Accordingly, the rejection of the counterclaim would be treated as a nil award of the counterclaim, and for the above reasons, it is stands set aside, and the matter is remitted to be adjusted afresh. The dictate of the High Court's granting intermediate pending also set aside.
Which paragraph you were reading?
Paragraph 11 it is. Paragraph 11 of this 194 4 SCC. In my compilation, you will see page number 81.
At that time, the 1940 Act was in force. Remission could be done under the 40 Act. But we do not think that any remand is possible under this Act, subject to correction.
I've given to say this is the
1994 decision. This Act is 1996.
I've given the principle.
So it must have been under the 40 Act.
So I'm coming next, you will see. So here you will see this 2019 volume 10 SCC 250.
The remand.
This also is received. This you will receive, it is reliable pages 9, 12, 13, 15, 22, 23, 24, and 26. But we can limit it only the paragraph 23 and 24 you will receive. May I read your receipt? Page 61 of my compilation.
Yes.
This is when discussed what the position of section 23 and 29 of the Arbitration Act 1996. Is it based on the judgment Probin Enterprise? It is given. Similarly, section 23 read with section 29 make it clear that respondent is entitled to raise the counterclaim unless parties are otherwise agreed, and also add and amend the counterclaim unless otherwise agreed. In short, unless the arbitrator agreed, required the arbitrator to decide only the specific refund dispute, the respondent can file the counterclaim and amend, add, or same except where the arbitration agreement restricts in the arbitration to only to this dispute, which are specifically referred to arbitration. Both the claimant and respondent are entitled to make a claim and counterclaim, and further entitled to add or to amend such claim and counterclaim provided they are arbitrable within the limitation. Then this subparagraph 29, where the arbitrator agreement required the disputes to be formulated and referred the arbitration by the appointing authority, and the appointing authority fails to do so, the Chief Justice or his designated will direct the appointing authority to formulate the dispute for reference as required by the arbitration agreement. The assumption by the court below that the reference of specific disputes to the arbitration by the Chief Justice or his designate is necessary while making the appointment arbitration under Section 11 of the Act is without any basis. Equally baseless is the assumption that where one party has filed an application under the Section 11 and get an arbitrator appointed, the arbitrator can decide only the disputed raised by the appellant under Section 11 of the Act and not counterclaim of the respondent. So, Your Lordship, this is the same that Your Lordship has just pointed out earlier. Now, paragraph 24. The question whether the issue regarding the certificate involved was outside the terms and agreement of such and such involved related to the agreement dated 1127 and 14/2009, and whether the arbitration whatsoever it falls the beyond the scope of the reference arbitration and such other related questions to determine only during the inquiry. It may be that after inquiry the arbitrator might reject the counterclaim or certificate involved are not arbitrable and the counterclaim beyond the scope of the reference agreement, but rejection of counterclaim at the threshold on the ground that arbitrators had no jurisdiction would not be proper.
Yes.
The High Court, in our view, has slightly set aside the award of the learned arbitrator. So you will see here in this straightway it was rejected, and due to this the award was set aside. Then after this, paragraph 26 given, in the result, the impugned judgment of the High Court, Bombay High Court, such and such, is affirmed and this appeal is dismissed. The observation of the High Court in the impugned order is para 10, it's the ability to convey credit legality specified in the certificate route may not be considered as a expressions opinion of the merit of the matter, the learned advice shall proceed with the matters on the merit in accordance with the law. No other. So here also in this case, you will see it is given when this arbitrator stateway has rejected this counterclaim, and for the particular purpose, it is on considering this issue, Your Lordship, the court is having the right to set aside the award.
Where are the counterclaims? On the last occasion, you said you would.
Your Lordship, counterclaim is here. This one. Page 112, Your Lordship, of the epic. And one, two is type copy, Your Lordship. Start.
One, two, two.
112, Your Lordship, this started, and type copy is 122. 1 and 2 is not readable. Let me say 5th April this type copy.
122.
Which 129? 129. 129.
So you will see the claim has referred in page 129. Claim number 1, extra amount incurred in completing the balance works through other agency at the risk and cost of the defaulting contractor. The amount of minus bill is rupees this 99,24,824.25, approximately subject to the audit check. The amount of final bill is tentative as the balance work is still under execution. The exact amount shall be indicated later. It is therefore paid before this tribunal planet arbitrated that this amount is awarded in favor of the Union of India. Claim 2, demission and upon the delay and utilization of the accommodation. As per work order number 1, Mrs. Jani Builder Private Limited The date of completion was to 8 April 2003. Due to the cancellation of the contract and on account of the contract's default, the risk and cost counted was concluded, and the date of completion works is 25th March 2004. Hence, there is a delay of 7 months and 17 days for the completion of the risk and cost contract. The kind of attention is learned and arbitration is invited there.
This is the usual. Please come to the next page. Risk purchase. 1, A, B, etc.
This given A, B, C, and then it is numbered again.
They terminated the contract.
Here is
According to them, you were in breach, so they terminated the contract. According to you, the termination was wrongful. So you had to get the work completed by another contractor and claim damages. So if their claim is allowed, automatically your claim is negated. But then he has done a mistake by saying that I have confined myself to 8 claims only. He ought not to have said that. Because he's a technical person, he doesn't know anything. You concluded your argument?
up to this minute.
Thank you. Yes, Mr. Khan.
Lordship, only on
law, Mr.
law
Khan.
points, Lordship. Lordship, before I go to the law points, one very important in my notes that I have given in Lordship. I just come to para 13, Lordship. Page 13.
Of the petition.
Lordship, the petition, the note that I gave, Lordship. I'll just take 2 minutes on this particular fact, then I'll reply on law points. Page 13, Lordship has got it. So, Lordship, para 24 is the application. My learned friend read out the counterclaim that was before the arbitrator. Now, this para 24 is very important, Lordship. This is the part of the 34 petition. The application that they filed for setting aside the award. In that setting aside of the award, in para 24 they pleaded this. And Lordship, para 50, the prayer, I have quoted the prayer. Prayer is very important, Lordship. It is therefore prayed that the Honour may be pleased to set aside the award passed by learned arbitrator, as there are basic errors apparent on the face of award, and as stated above, the award is liable to be set aside. Lordship, hurriedly, Lordship, two very important facts that I want to present here is that
Yes.
in their 34 application, though they have mentioned in para 24 about the counterclaim which was not considered. But in their prayer, it is the specific case, Lordship. They just want to set aside their claim. It was never the case before 34 that they wanted the court to set aside but to consider a counterclaim. This fact is very important, Lordship. So, Lordship, for last 21 years, since 30/11/2023, it is not the case of Union of India that they have approached under 34 or 33(4) or 34 asking for counterclaim. It is not the case of the.
Yes.
That fact is very important, Lordship. Neither they have built 33(4) nor even in 34.
Now, Your Lordship, on law point, Your Lordship, hurriedly, my learned friend relied on, first he relied on 13, no? 2023, Your Lordship, para 13. Page 63. Lordship, we'll just come to the first page of the judgment, which is at page 63.
Yes.
Lordship has got it. So, Lordship, my specific case is 33 sub clause 4.
Yes. Yes.
This Honorable Court judgment is about section 33, power of modification of an award and scope of a lawsuit. It is not the case of the appellant herein asking for modification of the award. 33 has got 1, 2, 3, 4, 5. I will not burden the court by reading everything, Your Lordship. Coming back to specific issue.
Yes.
33(4) is about claim for
Left
any
out.
additional claim.
Yes.
For any additional claim, the limitation period is 30 days, Your Lordship, from the date of award. And claim, Your Lordship, as I said, claim includes claim and counterclaim.
Yes.
So this judgment, Your Lordship, this for 2013, and Lordship will just come to para 13, which my friend has relied. Just to bring home the fact that the facts are very different. I'll just read the first 4 lines of this para 13, Lordship. The original award was passed considering the claims made by the claimant as per his original claim and as per the statement of claim made, and therefore this subsequently allowing the application under section 33 of the 1996 Act to modify the original award in exercise of his power under section 33 of the 1996 Act is not sustainable. So this judgment, Your Lordship, squarely is not applicable. It is not question of modification. So the factual situation of this 2023 judgment, Your Lordship, is not applicable in this case. There is no issue of modification of any original claim. 33(4) is about additional claim and counterclaim. So there is no application, Your Lordship. Lordship, next judgment my learned friend relied on was on 2024, page 69, 2024, para 7 and 8.
Yes.
Lordship, para 8, if I may read from the next page, Your Lordship, page 73.
2019.
2019.
Yes.
Sorry, Your Lordship, 2024 SSC online, Allahabad, page 69. 2024. 2024 SSC online, Allahabad, he is relying on para 8. The relevant page is at page 72. The important part of the Lordship starts from the next line, the authority of arbitral tribunal. Lordship is called.
Yes.
The authority of arbitral tribunal to correct, interpret, or supplement their awards does not extend to revisiting the merits of the dispute or reconsidering substantive issues that have already been decided. Arbitral awards are bound by the principle of functus officio, which holds that once an award has been rendered, the tribunal's jurisdiction over dispute is terminated and it lacks authority to revisit or modify its decision in absence of specific statutory provisions to the contrary. Lordship, the last part concerns me, but the previous sentence, Lordship, is about revisiting or modifying the decision. unless absence of specific statutory provision to the contrary. We have a specific statutory provision at 33(4), not for revisiting on merit, but for consideration of additional award. This has not been decided. Next, Your Lordship, 2019, page 54. I'll not burden this honorable court with the details relied on my friend, but I'll just rely on the first part of the judgment, Lordship, page 54. Arbitration and Conciliation Act 1996. The issue in this judgment was section 16 and section 11. A separate order was passed under section 18, not considering the counterclaim at the threshold. It is not the case with the of section 33. It was not the case with the award was published. So section 16, our cases does not come within the meaning of section 11 or 16. So the parameters of this judgment is absolutely not applicable in my case. Next, 1994 for SSC Lordship, I will just persuade myself not to reply, Lordship, because this is a judgment of prior to 1996.
Yes.
1994 will not be applicable in this Lordship, prior to. Last but not the least, Lordship, I just rely again on another one judgment my friend relied was on, though it's not quoted, para 2012, Lordship. This is again page 35. Lordship will kindly see the first page. The section involved which the court was asked to address was section 29, 8, 11, 16, 21 and 23. Lordship, 33(4) was not the subject matter. So the issue of counterclaim arose out of 16, 8, 11, 21, 23, Lordship. And these were all interlocutory stage. I will not burden the court. Lordship, this judgment also is not applicable. And Lordship, these were the only relevant judgments and
He has cited only 4.
Lordship, yes. But he did not read also. I thought all this because he was the trial court has relied on the judgment 2012. So I thought maybe he'll like to reply on that. So all these 4 judgments, including this, Lordship, the parametry and the factual situations are very different. Most importantly, Lordship, again at the cost of repetition, in 34th it is not the case. There is no prayer before that. The number one is that. Second is this, Lordship, they have not even challenged the 3/9/2024 order under 37. They never challenged for last 22 years the observation of the arbitrator that he had confined himself to only 8 claims. And Lordship, before I rest my case, one just clarity on the word claim. I'm grateful in Lordship. Lordship had just used the word 8 claims. But if you understand the meaning of 8 claims, the word claims, under 33(4), the word claim word is used in 33(4). That can be part of an additional award. Now, if you read in conjunction with 2(9), it means counterclaim. So when the arbitrator was Lordship, when the arbitrator was confining to the word 8 claims, the claims here, Lordship, my legal submission would be the claims, though directed by the Honorable Court, would mean claim under 2(9) counterclaim.
Yes.
And Lordship, so in that view of the matter, if I take to my written argument again, that the relevant page would be, I've just quoted for the convenience of this court, Lordship, the relevant part, which is at page 10. Lordship, it starts from page 9, the relevant part, Lordship. Just to conclude my argument, Lordship, page 9, the last part of my notes.
Yes.
Page 9,
Yes.
So I've quoted verbatim what the arbitrator had observed in his award. He clearly says, Your Lordship, I've marked it, highlighted, Your Lordship. Whereas so and so, the detail is that to adjudicate on the claim, I have marked it, Your Lordship, claim list of 8 claims as indicated in the petition filed on 28 August 2001. So, Your Lordship, the word claims has been mentioned as per the Honorable High Court order. The next paragraph also I've quoted, Your Lordship. Then he goes on to say, whereas I've entered upon the reference on 2 July and started the proceedings inviting both parties to submit their claims and counterclaims.
Yes.
It is admitted fact that the word claim here, as per Honorable Court, also would mean that the claims that the claimant filed,
Yes.
and by his own factual foundation in this paragraph would also mean that the claims would mean counterclaim as per the Honorable Court order. And he had allowed it. So he had not confined, Your Lordship, the learned arbitrator had not confined only to 8, within the meaning, limited meaning. His confining to 8 as per Honorable Court order would mean claim that includes counterclaim within the meaning of 2.9. The moment 2.9 comes in, Your Lordship, then the only statutory remedy for them would be 3.4. So I just want to clarify, Your Lordship, what has fallen from Your Lordship, that he should not have written the word only 8 claims. Perhaps maybe the tenor of language, Your Lordship, is absolutely correct. But then when you see the larger meaning of the word claim,
Yes.
it means claim and counterclaim, and he has rightly said this in the subsequent paragraph, kindly file a counterclaim. So the counterclaim that he has mentioned in his award would mean the counterclaim within the meanings of 8 claim that he is supposed to adjudicate. And the Union of India has rightly filed a counterclaim. Not considering that would come squarely will be covered within the meaning of 33.4. No, they have not availed that remedy. Even in 34, they have not. It is nobody's case, Your Lordship, that they are asking the commercial court to set aside the award or to accept the counterclaim. So for 22 years, it is the Union of India. It's not the Union of India's case. They agree by any counterclaim that was not considered by the arbitrator. That's my limited submission, Your Lordship.
Please take down. You want to submit written submissions? Or it is okay? We have taken notes.
This is already.
Hearing concluded, stop, CAB. Full stop. We have taken on record the written submissions filed by Mr. Khan, learned ASG, on behalf of the appellant. Finish.